All right, Senator Hewitt.
Thank you, Mr. Vice Chairman. So, members, this is Senate Bill 148. This is the seatbelt bill that has been a topic of discussion now for a couple of years. And, you know, the bill has been changed from last year. It has been stripped down. It is basically saying that the judge may inform the jury of the issue of not wearing a seatbelt. And I know that there's been some discussion about an amendment from Senator Martini that I would think would be an appropriate time to introduce, if it please the chairman.
All right, this is Amendment 1166. It's being handed out now. And why don't you explain your amendment to Senator?
I think, yeah,
I'm
Senator
sorry, Senator
Martini.
Martini's amendment.
Yes, sir.
Okay.
Thank you.
Can we get one more, please, sir?
I'm sorry.
This would be in line with what I discussed on the last bill. The bottom line is you couldn't, right now there's a prohibition against even mentioning it. Now it would be, I mean, I don't think we want to do it to where the example that I gave Senator Donahue, you know, you're sitting in your car reading your newspaper and an 18-wheeler comes along and runs over you. Seatbelt, not wearing a seatbelt had absolutely no relevance to that particular claim. Court could then make that finding and say, no, we're not going to let that in. On the other hand, what this does do, and it does for the businesses that are supporting this, it gives you the opportunity to have a judge look at it and make a ruling. If the judge makes a ruling that, I mean, that is clearly contrary to and clearly an abuse of discretion, you can go to appellate court and say that evidence should not have been excluded because it clearly either contributed to the accident or contributed to the severity of the injury. So that would just simply say it can go in, but only after a court has a hearing on it and makes a finding that it is relevant and admissible.
All right, we're gonna continue discussion. We're not going to vote on this amendment this time because we lack a quorum. We've had several other members that have to go to other committee meetings, and we don't have a quorum at this time. But let's just continue on with the discussion of the bill at this time. Senator Hewitt.
Well, again, I appreciate the fact that the chairman saw the wisdom of including seatbelt legislation. This accomplishes basically something similar to what I think he was doing in his bill. This is a clean bill, though. It doesn't have the issue of prescription. And as was pointed out by Senator Gaddy and others, you don't ever know exactly which bills are going to move through the process. I think that this would make sense to me for this bill to move forward. The committee's already, kind of shown their acceptance of the seatbelt gag rule being lifted. And so, I think that now is the right time for this bill, and there are a few folks that would like to make a couple of comments on it.
Okay, thank you, Senator Hewitt. If you'll please introduce yourself, gentlemen, and whoever wants to go first.
Darren, why don't you go ahead? Darren O'Connor, here on behalf of the bill. Senator, we appreciate your time, and certainly there's been comment that's been made before that I think the committee recognizes that this is just a piece of evidence that where relevant should be heard submitted to the jury if the judge deems it to be relevant. I don't think it changes anything that's out there at the present time. As you know, as an attorney, that all evidence, it goes through the judge to determine what goes to the jury, and I don't think this changes that at all. It just reinforces that if it's deemed to have probative value, and the judge certainly believes that it should be submitted to a jury, that it's done that. And I think clearly this is a bill that addresses a seatbelt issue where we know you can be cited for, we know that you can pay a fine for, and I don't think there's many other things that I can think of as an attorney that you could be cited and pay a fine for in a motor vehicle accident that could not eventually at least be discussed to be submitted to the jury. So I think it's a common sense approach that it's something that should be considered and passed where relevant that the jury hears that evidence.
All right. Thank you very much, Mr. Albright.
Jeff, excuse me, Jeff Albright with the Independent Insurance Agents. As I mentioned when we debated the chairman's bill earlier, we're very much in support of the bill and be happy to answer any questions. Appreciate the amendment.
Okay, well, the board is cleared. I'll read in the cards in support and the card in opposition. We have a card in support, Commissioner Jim Donelon, Louisiana Department of Insurance, Kerry Koch, Louisiana Loggers Association, Karen White, Louisiana Municipal Association, Lauren Chauvin, Lobby, David Tatman, Louisiana Surplus Lines Association, Sandy Mapes, Farm Bureau, Renee Armour, Pelican Institute, Lana Venable, the Lawsuit Abuse Watch, Brandon Brewer, LMA, Michelle Shirley, Home Builders, Jim Harrison, Jenny Martinez, Louisiana Coalition for Common Sense, Kim Calloway, Louisiana Realtors, I can't read the first name, Leday with GNO Inc., Rodney Braxton, State Farm, Jeff Albright, Independent Insurance, Don Sturds, NFIB, Kevin Ainsworth, Progressive Insurance, Ron Dual Insurance, Jody Boudreau, Professional Insurance Agents, Lou Fay, Professional Insurance Agents, Paulette Bailey Wilson, Louisiana Municipal Association, Matthew Spradley, American Sugarcane League, Jordan Gleason, Loga. And we have two cards to provide information, Bobby Breland, Louisiana Highway Safety Commission, and Richard Piazza, Insurance Department. And then we have one card in opposition, Mr. Robert Kleinpeter, who is president and would like to speak. Mr. Kleinpeter, do you want to speak? Okay. All right, he waived speaking. Senator Hewitt, we don't have a quorum. I don't have the great expectations of having a quorum back because everybody that left had other committee meetings to present bills in. So we're going to have to hold yours over to next week. We won't make you sit here through another entire hearing next week. We'll take your bill up, and if there's anything else that wants to be offered at that time, you're certainly welcome to do that.
Thank you, Mr. Chairman.
All right, thank you.
Senator Hewitt, if you'd like to come and pick up where we left off last week.
Did you need a copy? Have a great day.
There you go.
Thank you, Mr. Chairman. Members, this is Senate Bill 148. As you recall, this bill is going to allow juries to be given the facts about seatbelt usage as it could relate to an automobile accident. This is a common sense bill. It was a carryover from a law from the 1980s when seatbelt usage was not the law and seatbelts became the law. And this statute was passed at that time so that people could we weren't going to be too heavy-handed because seatbelt usage was not the common practice at that time. Now, fast forward 2019, seatbelt usage is the expectation. And I believe that it's only fair for the juries to be given an opportunity to know if someone in an automobile accident was not wearing their seatbelt. And so I think this is a common sense bill. Juries can be told many things. They can be told if you're texting while driving. They can be told if you're drinking while driving. They can be told if you were breaking any kind of a law. They can be told if your children weren't strapped in appropriately. This is a holdover from the early 1980s. It's a common sense bill, and I think that we need to move this bill forward. Mr. Chairman, I do have an amendment for the bill. We could consider that. I would appreciate
All
that.
right. See if we can get those passed out here. And in the while we're doing that, we do have a question from Senator Milkovich while we're getting those amendments.
Thank you.
Thank you, Mr. Chairman and Senator Hewitt. I've got a couple questions. Of course, it's my understanding that Senator Ward and this committee have passed out a bill already that could permit this evidence to go to a jury. So that's one concern that I have. A second concern is, I think you mentioned, and I don't really know who the ultimate sponsor of this bill is. I'm not sure if you're in a position to say. I mean, if you are, if you're in a position to say, you can, and if you're not, I'll respect that. But I do note that in the same session of the legislature that and again, I don't know whether this is a particular lobbying group or the insurance industry or maybe it's citizens in your district. I don't know. But what I can say is that within the same legislative session, we've had bills saying, we want transparency. We want jurors to know whether they're seatbelts or not. And of course, as I said, Chairman Ward and the committee have passed a seatbelt transparency bill. But in the very same session, my understanding is that there's another bill, and again, I don't know if it's presented on behalf of the insurance industry or a particular lobbying group that says, we don't want jurors to even know if there's an insurance company. So we're saying, when citizens' rights are at issue, I'm seeing in these legislative packages some selective transparency, if you will. We want jurors to know whether they wearing seatbelts. But we don't want the jurors to know whether there's a multi-billion-dollar insurance company that provides coverage to protect the injured party. So I'm gonna state on the record my concern for selective transparency. Transparency is good or it's not good, but when we pick and choose, and the picking and choosing, I think one of the things we need to look at is that selective transparency in the interest of Louisiana citizens, the 4.3 million people, give or take, that live here. And I have an additional concern about your bill, and I thank you for pursuing what you think is a valid legislative initiative. So we commend you, and I'm sure that's the sentiments of everyone in this committee, and I'm sure in the room as well. But so number one, the transparency's been selective. We want the jury to know about seatbelts, but we don't want them to know if there's a multi-billion-dollar liability insurer that's covering the at-fault party and potentially providing protection for the injured party. An additional concern is I don't see in your bill any attention to a very important evidentiary facet of seatbelts in the causation and extent of injuries. As one practitioner stated to me, and with tons of research to back up what he says, seatbelts save lives, but they kill spines. That is to say, seatbelts are very positive, and I think, this committee, at least myself, I want to go on record saying everyone should use seatbelts, because the problem is if you're not wearing them, you get thrown out of vehicles, and that can be highly injurious, if not worse, to the occupants. But in instances where the person was not thrown from the vehicle or would not have been thrown from the vehicle, the fact of seatbelt actually renders the angles of spinal contortion and spinal angulation in car wrecks more acute. And people that treat spinal injuries say that seatbelts cause a more severe torquing of the lumbar and cervical spine and actually make those injuries more acute, more serious, more long-term. What I don't see in this particular bill is anything that says if we're going to let the jury see everything, would, for example, we all know people that have been in a car wreck and 20 years later they're still not the same. And there may be a few of those people in this room. Would a jury be allowed to receive lay and expert testimony about the extent to which a seatbelt increases the angulation of the spine post collision, and the extent to which that actually increases spinal injuries? So those are my concerns. Number one, I think we've passed a bill that addresses what you said. Number two, I'm concerned about a selectivity of the transparency. And number three, the bill does not state that if a friend of ours from Ville Platte gets hurt in a car wreck and he's wearing a seatbelt and he's got neck and back injuries for the rest of his life, this bill doesn't say that he can actually take to the jury the scientific evidence, and it's in the literature concerning the biomechanics of wrecks and that seatbelt tethering the spine actually increases injury. So I'm sharing with you some of my concerns about the bill, and obviously, Senator, you have the right to respond to those. concerns.
I appreciate that. I think some of those were statements, and maybe there were a few questions weaved in there, but I'd like to try to
It was
respond.
mostly statements, but you certainly have the right to respond to each and every one of those.
I appreciate that. On the issue of transparency, first of all, I'm not going to link this bill to other bills, and there will be others, I think, that are presenting their bills today that you're going to hear that will speak about the merits of their bill. I will say, though, that wearing a seatbelt is a state law. And what we're asking is for there to be consideration for the jury to be told about that. And the other issue that you talked about that I think will be discussed in the other bill, we're not talking about state law there, we're talking about something different. I do have an amendment that I believe that we'll get to hear in a few minutes that is, I believe, going to help address maybe some of your discussion about, spinal injuries and all those things. What this amendment is going to do is it's going to provide for a hearing outside of the jury where all of those kinds of points, I believe, could be made, whether the issue of wearing a seatbelt or not is relevant, whether it matters in terms of negligence, whether it matters in terms of damages. I think that is the opportunity to discuss that. I think there is a lot of data that shows that wearing seatbelts does reduce injuries and it does save lives. But on a case-by-case basis, I think it makes sense for all of those things to be debated and for the attorneys and the judge to have an opportunity to discuss that outside of the jury. And so my amendment, when we have an opportunity to hear that, I think will help address that.
All right. Do we want to go ahead and take up that amendment? Does somebody want to offer that amendment? All right, Senator Donahue will offer that amendment. I think we have, Senator Luna, I'm going to hold your question until we take a look at this amendment. You have a question on the amendment, Senator Martine?
Thank you, Mr. Chairman. Senator, I'm going to ask you to withdraw the amendment and resubmit it. Basically, I would put the same thing in there, but I would say the admissibility of such evidence shall be determined by the court it says out of the hearing, I guess out of the hearing of the jury in which the issue of whether or not the plaintiff, and I'll ask staff to clear this up a little bit, the plaintiff's not wearing a seatbelt shall be made, a determination shall be made in accordance with Articles 401 and 403 of the Code of Evidence. And it really just deals with, I just don't want to leave it hanging out there just saying the judge gets to decide. I want to make sure that the judge is bound by the rules of evidence that say it's got to be relevant. It should also lend itself to the issue of probable cause of the proximate cause of the accident and the injuries. I used this example last week. You're sitting in your car not wearing a seatbelt, sitting alongside the road, and an 18-wheeler comes and rolls over and kills you. I don't think that whether you had a seatbelt on or not was going to be relevant to that. In the same way,
I agree.
the car hits you from the back and you go through the windshield, then they can make that determination. That would be my suggestion. I support your amendment, but I think it ought to be more detailed. Thank you.
All right. So are we drafting a new set of amendments, or do we want to adopt the?
Mr. Jones.
All right. Well, Senator Donahue, if you're okay with that change, we're going to hold on this for a second, and we're going to continue with some questions here. Senator Luna.
Thank you, Mr. Chairman. Senator Hewitt, tell me what the purpose of your bill is to put this information before the jury. What are you trying to accomplish?
Well, for one, I think the jury needs to know all the relevant information, like wearing a seatbelt, because I think the presumption on the part of the jury right now is that everyone is wearing their seatbelt. I think that's what reasonable people do, is wear their seatbelts. And I do think that it could play a factor in terms of determining negligence or mitigating damages.
So to reduce damages, that would be the end goal?
They just need all the information. So
Yeah,
maybe it would reduce damages, maybe it wouldn't. Maybe it wouldn't be relevant, but I do think that they need to know that information.
And I understand that you're wanting to get the information because you feel like they need to know that. I understand that part, but what I'm trying to get at is, what's the goal that you're looking for here? Is it to reduce insurance rates? Is it to help reduce cost of litigation, or what typically is the goal?
Well, I think all of those things would be positives. Do I believe that just one bill is going to do all of those things and be the silver bullet to reducing car insurance rates? No, I do not.
Yeah,
But I
didn't
do
think you meant
believe,
that.
but I do believe that it is moving us in the right direction. There, all of the other states have already taken this action. This was very common language back in the 80s. Most states have reversed this language now and given the juries the opportunity to hear this information.
Did you research the states that have this rule and the ones that don't?
And I did, and I did not bring all that information with me. As you recall, we debated this issue extensively last year for about 3 hours.
Right.
And we went through a lot of that information last year.
And as I recall, I do remember that, and I pulled up some of the information I had from that debate too. Were you aware that the states with lowest insurance rates do not make this admissible to juries, do not make seatbelt use admissible to juries?
I think that, in any of these issues, you're not going to find consistency among states on everything. We talk about that in terms of taxes. You can't just pick one state and one tax and say, we should do that, because you have to look at the whole package.
And I understand that your response, but that's not responsive to my question. My question deals with, if we're trying, one of the goals here is to lower insurance rates, the states that have the lowest insurance rates in this country do not make seatbelt use admissible. So that's troubling to me if that really is the goal of what we're trying to do.
Again, I don't think that insurance rates are related to just one issue, and I would suggest to you that those states are doing a number of other things differently than we are.
What kind of things are they doing differently than we are?
Well, we can go through all the individual states perhaps at a different time, but I would submit to you that
I guess what I'm getting at here, and look, I understand where you're coming from, I do, but I think that what we're doing is, I think there are a lot of people with special interests that are making the public believe that this is a silver bullet. And you and I agree that it's not a silver bullet. It's not going to fix those woes. Now, the real question is, if we're going to do this, do we do it in a fashion such as your bill or Senator Ward's bill? Do you have issue? Do you take issue with Senator Ward's bill, or are you okay? The language is almost the same, isn't it?
Well, it has some similarities. I think there are some differences, certainly. My bill, of course, does not have the prescriptive period in it. I'm not sure if Senator Ward's bill has damages in it. It certainly doesn't have the suggestion that Senator Martini just made in terms of tightening it up with article whatever. Okay, so we're going to add that to this bill. I think this bill has been debated. It was debated last year for about 3 hours. A rather spirited and in some cases an aggressive manner. This year, as you've pointed out, the chairman chose to add similar but not exactly the same language onto his bill, passed out of this committee with flying colors, and then lost a quorum while you were chairing the committee, lost a quorum.
Okay, can I
we didn't
stop
have
you?
the ability to be able to vote on my bill.
I understand that. I was here, I remember.
I think we need to kind of quit the gamesmanship, and we need to give this bill an opportunity to get to the Senate floor.
Which is exactly what I'm trying to do here, is because I think there is a lot of gamesmanship going on here. Let me ask you this. Senator Ward's bill makes the changes that for seatbelt admissibility in the Code of Evidence. Your bill makes it in Title 32. Why did you pick Title 32 instead of the Code of Evidence?
No particular reason.
My problem with your bill as it stands now is that it is in Title 32 and it's going to conflict with the Code of Evidence. And typically the codes are given greater weight than the statutes are in that manner. So it's going to, your law is going to directly conflict with the Code of Evidence. Senator Ward's bill changes the Code of Evidence as to admissibility. I think admissibility should come under the Code of Evidence, not Title 32. Typically, when you talk about what's admissible and how it's admissible in a trial, that comes under the Code of Evidence. It doesn't come under the various statutes like Title 32. So I was trying to find out if there's some particular reason why you did that, if it makes a difference other than it's going to conflict with another area of law.
Well, Title 32 is where the seatbelt language was initially put, right? That made it where you could not, it was not admissible. So that made, to me, it was a logical place to amend it.
It's actually in the Code of Evidence. But in any event, okay. I appreciate your time. Thank you.
Thank you. The only thing I would add was on on Senator Martini's amendment, the language that you were, I think, alluding to, that my bill didn't have. The reason that my bill did not need it was because it was inserted into the Code of Evidence, so it's already subject to the Code of Evidence and all the rules that go along with it. So the the language that went with it did not need to be expressed. All right, Senator Martini, do you want to offer your amendment?
Sure. Yes.
Oh, well, Senator Donahue, would you like to compare his amendment with yours? And
I mean, I think Senator Martini's intention that the language that Senator Hewitt has in the amendment is put in the code correctly, and I agree with that.
okay, all right.
So-
You can be your amendment, sorry. If
It
you want to
can be
withdraw
your
yours,
amendment, Senator.
That's fine.
Whatever.
Then you just withdraw yours, and
I'll withdraw my amendment.
All right, so there is an amendment offered up by Senator Martini. Hearing no objection, that amendment will stand adopted. Jerry, and just so everybody on the committee is clear, can you read and let everyone on the committee as well as the room know? I believe everyone up here knows, but I'd like for everyone else as well to understand exactly what that does. I mean, there you go.
Yes, sir. The amendment just adopted would, on page 1, delete lines 11 and 12 of the bill and insert, it would strike out the word negligence and insert the word fault or to mitigate damages, period. The admissibility of such evidence shall be determined by the court out of the hearing of the jury and shall be subject to the provisions of Article 401 and 403 of the Code of Evidence.
Thank you. All right. So I think that's it. We do have cards in support, none of which would like to speak, but might take me a while to read through. You're doing well, Senator Hewitt. I didn't have nearly as many in support of mine.
They didn't know you were going to offer the seatbelt language on your bill, probably.
Commissioner Donnellan, Todd Murray, Jefferson Chamber, Dawn Storms. That's what said Todd Murray.
Murphy, you said Murray.
Did I say Murray?
You were close.
I was close. I meant to say Murray. Dawn Storms, NFIB, Matthew Spradley, American Sugarcane League, John Hightower, Kevin Cunningham, Kim Calloway, Jim Harris, Louisiana Coalition for Common Sense, Logan Anderson, Baton Rouge Chamber, Karen White, Louisiana Municipal Association, Eric Berger, Gray Insurance, Lauren Chauvin, LABI, Johnny Coke, I'm not sure, let's see, Hospitality of America, I think, Brandon Brewer, LMA, Jordan Gleason, Loga, Carl Mears, Razorback Rentals, LLC, Jody Boudreau, Professional Insurance Agent, Lou Fay, Professional Insurance Agent, Al how do you say that?
Al Papalato Jr.
Papalato Jr., Professional Insurance Agent, Kerry Coke, Stephen Wagaspack, LABI, John Gallagher, LMA, Lana Venable, Louisiana Lawsuit Abuse Watch, Renee Amar, Pelican Institute, John Walters, Associated Builders and Contractors, Sandy Mapes, Farm Bureau, Billy Yelverton, Farm Bureau. All right, went through them all. And then we have one card in opposition, Robert Kleinpiener, Louisiana Association for Justice, and he is here and does wish to speak. And we do have something from Senator Donahue.
Thank you, Mr. Chairman. Senator Hewitt, it's good to see you here again. Thanks for bringing that bill.
I love Jude.
Me too. So when we talked, you were talking before about the purpose of the bill. I mean, originally, as you intended the bill, you're bringing the bill with the hopes that you're going to lower insurance rates for drivers in the state of Louisiana, correct?
Well, again, I don't think any one bill
No, I
accomplishes all of those things, but I do think that juries need to be told if you were following the law and wearing your seatbelt. I do think seatbelts save lives and reduces the severity of injuries, and I think that where that issue is relevant, the juries ought to know that. And perhaps if there are less injuries, then you have lower jury awards and maybe ultimately lower insurance rates.
Right, and I think you said that very well. So, how does Louisiana stack up with insurance rates?
We're the second highest, my understanding is we're the second highest in the country.
So, like, do you know what our average insurance rate is as advertised?
It's several $1,000s, I think, per person per year.
And do you know what the national average is?
I could probably find all that information, but I didn't.
But
It is. We're way out of line in terms of insurance rates.
all right. Listen, thanks for bringing the bill. Thank you, Mr. Chairman.
I appreciate your question, Senator.
All right. We'll hear from the opposition.
Thank you, Mr. Chair and committee members. My name is Bob Kleinpeter, here on behalf of the Louisiana Association for Justice, our members, and the hundreds of thousands of clients and small businesses that we serve. I'll make 3 points. I'll be brief. This bill is well-intentioned and it is ill-advised for the following reasons. Number one, and some of these metrics were mentioned, but I want to clarify them. The 10 states with the lowest insurance rates, and actually it's more than that, but I'll just pick those 10 with the lowest, have the rule in place that we have right now. So all we have to do is do nothing, and we are consistent with the 10 lowest automobile insurance rates states. If we are to do the converse, and let's flip it, and let's go look at the states with the highest rates. Well, Louisiana, depending on what kind of policy you're looking at, are you looking at a base policy 15, 30, 25, or are you looking at one with comprehensive and collision? But if you go look at the top, we're sandwiched in between Michigan and Florida. Michigan and Florida have admissibility of seatbelt use. So we are leaving the good rate states that are down, and we are chasing the bad or high auto insurance rates states by making seatbelt use admissible. Another point, the vast majority of states have our rule, which is that seatbelt use is not admissible. Another very few points on metrics. Our rate is about that of the national average. We've been steadily trending upward, and seatbelt violations are a primary violation, so they can be written up by any peace officer, deputy sheriff, state trooper, Baton Rouge City Police, whatever. The states with the highest automobile insurance rates usually put in about a 5 to 15% mitigation of damages rate in their statutes. Let me move next to history and utility. We've had the bill in place for 30 years. We tweaked it back in the 80s and had a 2% rate, but we got away from that. And as I said, you've got a primary violation now, which we've moved toward. But more important, let's talk about the utility part of that. And baked into the statute are utilities. In other words, we recognize, or the legislature in its wisdom recognizes there are utilities to not wearing seat belts for certain professions or activities, farming and mail and such. So let's think about that from a very practical standpoint, and Senator Martini touched on it. Is there utility in our citizenry for not at times wearing a seatbelt? A seatbelt can't cause a wreck. Seatbelt can't. Now, if you are doing an activity, okay, that causes a wreck, I mean, that's part of the calculus and should certainly go into the equation, and the jury should consider it. But let's say workers in a work truck, co-worker left a water bottle on the floor. The water bottle's rolling around. The worker says, I'm going to take this seatbelt off at the next red light or stop sign because I don't want to get that thing caught between my foot and the accelerator, or even more importantly, between my foot and the braking system. They take their seatbelt off, reach down to get the water bottle, and they get smacked by somebody at 40 miles an hour who hadn't had sleep in 3 days. Okay? Now, where does that damage go? Where does the equation of allocation of fault go? Should it be allocated to the worker who's trying to do the right thing and not have this dangerous water bottle potential risk hazard on the floor? Let's make it more prosaic. Let's have a soccer mom or dad who's picked up food going back to the house. They got more children to take care of there, and food spills over. They don't want to lose the food. They don't want to lose the value of the food. They don't want the food to ruin their car. So they either pull over or they, again, pull up to a red light, stop sign, take off their belt for the limited purpose of harvesting the food that they can and stopping the damage from being done. Again, somebody hits them, not their fault. Seatbelt didn't cause the wreck, but we're going to penalize them under this bill. Let me give you the last point. I've carefully listened to the testimony, not only in Senator Hewitt's bill, but also Senator Ward's bill. Seatbelt wearing is not a binary issue. And by that I mean it's not like they were wearing a seatbelt, they're not wearing a seatbelt. I mean, it would be easy if we knew that for a fact, but see, seatbelt use is in and of itself a fact issue. So as a practicing attorney, somebody who's been doing this for over 40 years, this is what's going to happen. You're going to have entered into the checklist of questions that Insurance Defense Counsel, Institutional Defense Counsel ask of the plaintiffs and witnesses, questions like this. These aren't just abstract hypotheses. I mean, this is going to happen. Every case you're going to have seatbelt use be an issue. What happens with these real-life hypotheses? 3 medical records say she wore a seatbelt at the time of the collision. 1 medical record says not. Well, that was a clerical error. Somebody just put a not. They got interrupted. They were looking at their Facebook. They got a phone call. But hey, now it's in the record. Is that an issue of fact? Well, you can darn sure bet the defense counsel is going to make it an issue of fact. Let's go to another one. There's a death. There's a traumatic amnesia because the crash was so bad. Were they wearing a belt or not? I mean, the person who's with traumatic amnesia can't testify about it. The person who's deceased can't testify about it. What if the EMS responder has a place for seatbelt use, but because they're trying to save a life, they don't check the box? That's now a fact issue. So what if you have medical records that all say seatbelt use, seatbelt wearing at the time of the collision, but the defense medical exam, the doctor says under oath at the deposition, or in his report or her report, that, well, when I questioned the person who I was examining, they seemed hesitant and they equivocated and it was unclear to me. And so they write that in their report. Does that become an issue of fact? And all of these things are going to be litigated, and then they're going to become part of reports and depositions and motion practice, and ultimately they're going to have to use court resources, and it's going to happen in just an explosion of cases because you're inviting this issue, which is why I would think it's a reasonable inference. That's why these other states that are lower than us, I can't say it's causative, it's a good correlation, they just don't get into all this mischief. So transaction costs, according to our knowledge of how insurance is rated, I mean, the loss experience, Commissioner Donlan always says you start with loss experience. Part of loss experience is transaction costs. Transaction costs include all of these things that I talked about. So for those reasons, we oppose the bill.
All right, thank you. Senator Hewitt, if you'd like to come and close. Oh, you do have them? I don't, it doesn't, it's not showing up, but here you go. Mr. Klein-Peter, I think there was a question for you from Senator Donahue.
Excuse me, Senator, I didn't mean to run off.
Good morning. So you were talking about Michigan and Florida. They have, what was it that was significant about Michigan and Florida?
The rules they have, they allow admissibility of
But the point was their rates are higher or lower?
Their rates are, well, we're sandwiched, depending on, Insure.com or NerdWallet or whoever you're looking at, their rate, we're up with them in auto insurance rates. So our rates are high, their rates are high, and we're chasing, and these seatbelt use admissibility statutes or that were, enactments that we're discussing would put us in line with them, and their rates are high. So my point, which I did the best to make, but my point was, states with the lowest rates, the lowest automobile insurance rates, our admissibility statute right now, or admissibility law is they're inadmissible, and so are those states too. So changing the law to make seatbelt use admissible, and a question of fact would put us with the states that are the higher states, and the highest, as a matter of fact, Michigan and Florida, and we would make them admissible.
So one of those, Michigan is higher than we are, the highest in the country?
Well, from most of the rating that we look at, Michigan is a higher rate than Louisiana. Yes, sir.
And Michigan is must be in third place, right below Louisiana.
Florida is.
I said Michigan. I meant Florida. Thank you.
Yes, sir.
So when I'm looking at the bill that is being presented and the way it's amended, and the cases that you were talking about, with somebody reaching down to pick something up, probably has happened to all of us at one time or another. But I mean, if you have the judge listening to that evidence outside the jury and making a decision as to whether that evidence is admissible or not, why would you have a problem with that?
Well, because the statute is so capacious that
It's so what?
It's so broad. It so allows so much information in.
He's only in his second year of law school.
The statute allows so much information in that, I mean, who's to say, I mean, does this go to allocation of fault only? Does it go to damages only? And what other information is there?
Isn't determination going to be made in the case that this bill passes as amended? Doesn't the judge then make that decision? And I can't figure out why you have a problem with judge deciding. So if in a case where they dropped a bottle of water on the floor and wound up having an accident and taking the seatbelt off, maybe the judge would say, we're not going to consider that, and the jury's not going to hear that evidence. So, in the case where somebody just doesn't wear their seatbelt and they're thrown out of the vehicle, and the judge might say, "Well, listen, I think that's significant. So why wouldn't we want the jury who's making a decision about the case? Why wouldn't we want that jury in that case to have that information?"
Because the judges right now, I mean, with respect, I don't believe, and no one has greater respect for the judiciary than I, but I don't think there's enough information for them to use their abuse of discretion standard in a wise manner to determine what exactly the jury might hear or not. And even with that, you're still going to cause all these transaction costs because defense counsel understandably will use every tool in the toolbox available, which now is seatbelt use or not. So all of these things, they're going to constantly.
To me, sir, if it's relevant, it ought to be in there so it can be considered. I appreciate the questions and answers. Thank you, sir.
Yes, sir.
All right, to Mr. Kleinpeter?
Yes.
All right, Senator Luno.
Thank you, Mr. Chairman. Mr. Kleinpeter, let's just talk real briefly about the nuts and bolts of this. You talked about two aspects, the issue of whether or not they're wearing a seatbelt and then the damages issue. How do you go about proving, how would a lawyer prove in court on the usage issue if there's a dispute about that?
Well, there's two methodologies available. There's circumstantial evidence and there's direct evidence. So, for example, if there's three people in an automobile and nobody was knocked unconscious or what have you, you can ask someone
And I guess what I'm getting at is what I would view, or what I know, is a more expensive aspect of that, and that's experts. Could you prove that through the use of experts?
And excellent point, Senator Luno. So if someone says, I don't remember whether Ryan was wearing a seatbelt or not, well, does that create an issue of fact? But then we can go to mechanical engineers and biomechanics and accident reconstructionists. So let's say, well, I can't remember whether he was wearing a seatbelt or not. Okay, let's go get an expert. So you go get an expert. The mechanical engineer says, oh, I see a witness mark. It looks like loading occurred. But then it becomes a question of fact. Is that a recent loading mark, or does that mark look a bit old because there's fraying and there's dirt?
I'm trying to get to a real finite point here. When you have that issue and you have to have experts, each side hires an expert and they present their information to the judge in a hearing to make this determination? Is that correct? Is that the methodology?
Well, and ultimately a Daubert hearing.
Right.
Under 1425.
So that means that we would be increasing the cost of litigation by adding another step into it for this instance.
And increasing it significantly, transaction costs significantly.
And then the next step would be if the judge finds that there was not seatbelt usage, then you would go to the damage aspect of it, and during the trial you would present experts, would you not, in medical field, to talk about what would have been heard if you had been wearing a seatbelt versus what was heard when you weren't. Is that correct?
Biomedical engineering, along with accident reconstructions, to provide the foundation for the methodology for the biomedical engineer.
Let's just say that the doctor component of it, the medical end of it, was going to be an orthopedic surgeon. What's generally your experience with how much they charge per hour to come testify and give depositions and come to trial and testify and things like that?
The cases that I'm involved with right now, the orthopedists, are you saying, or the biomedical engineers? The orthopedists are $10,000 a day. The biomedical engineers are, several $100s, at least a few $100s an hour, $375 an hour to $500 an hour.
One last thing, it's my belief, and you tell me if you disagree with me, if you think I'm wrong. It's my belief that in the states where they allow seatbelt usage, there is a cap on the reduction of damages from 5 to 15% in those states. Am I correct in that?
That is correct. The states that do allow it cap it like we used to cap it back in the 80s. But those are the high auto insurance rate states that we purportedly want to go away from.
All right. Thank you, sir.
Okay. You want to come up and close, and I have a question for you, and I can do it now. I can do. Let me just say this. I want to talk about the two-tone elephant that's in the room that nobody's talking about. I like your bill. I like your issue. I think I've supported your issue from day one. And after we had that little snafu last year where you got the bill out of transportation, got sent back here. But I think the concept is a good concept, and my amendment hopefully will improve it. That does not, and I guess I can say this since I'm not coming back anymore, and nobody can threaten to vote against me or whatever. What people are concerned about is not this bill. What people are concerned about is that if this bill gets out of here, what's it going to look like when it gets on the Senate floor or off the Senate floor? And I mean, and I'm not asking you to commit that you're not going to pick up a hitchhiker or whatever, but that's the biggest concern. I voted for Senator Ward's bill. I'm not real wild about the 2-year prescription because of the type of legal work that I do. I want to know about it. I don't want to wait 2.5 years to find out that somebody's suing a governmental agency, and that's who I represent. But that's the concern that I have, not about the merits of your bill. But and again, you can comment on that, or you don't have to. I understand the process, and you can make all the commitments you want. I know I've had to make those commitments in my 25 years here, where I've told people if the bill gets amended in this fashion, I'm not going to go forward with it. So that's the consideration that I have. And again, you can comment on it or not comment on it, but that seems to be the reluctance of some people to support not the idea, but this particular bill. Thank you.
All right, Senator Hewitt, would you like to close?
I would.
All right.
Thank you. And thank you for that question, Senator Martini, and I will address that. You know, I think it's interesting to me that the last witness didn't choose to testify last week when we were talking about this issue of seat belts, when we were debating it on the chairman's bill. And that was the ultimate hitchhiker, right, when the chairman amended my language onto his bill. So, you know, at this point, no, I'm not ready to commit as to what might happen to the bill going forward, should it leave this committee. But I think that there's 4.6 million people out there in the state of Louisiana that would like to see this bill move forward. I think that some of the scenarios that the last witness talked about are all very interesting, about water bottles and what have you. And in the past, we've talked about pacifiers and baby bottles and what have you as scenarios. I think that is exactly why you need to look at these on a case-by-case basis and allow that to be debated on a case-by-case basis between the attorneys and the judge, and allow that to be considered. I also do not believe that you can take one policy and leap to the assumption that that is the reason why car insurance rates are different. So in the last example, when the gentleman was talking about different states that have higher or lower insurance rates than ours, it is not just one thing. It is not one thing, and we know that. Bottom line is, the way you reduce car insurance rates in the state of Louisiana is you have to have fewer accidents and fewer lawsuits. And I think that, you know, those states that maybe have lower car insurance rates are doing a number of things differently than we are. Perhaps they have fewer bodily injury lawsuits. Perhaps they have differences in jury thresholds or direct action or collateral source. Perhaps they have different laws relative to distracted driving. And we have had a number of bills in the Senate Transportation Committee where I serve, where there's been a lot of work done on many of these issues. And I think that all of those things are moving us in the right direction. I think that this bill is part of that. And I would encourage you and ask you, this bill has been debated now for 2 years. And to the issue that Senator Milkovich brought up early on, I know that the chairman has similar language, although it does not include damages on his bill. I would ask you to give us a clean bill on the Senate floor that we can debate and we can talk about. And so I would ask for your favorable consideration.
All right. And Senator Hewitt, I appreciate you coming back again this week. I know we didn't get to finalize last week, so I appreciate you being willing to come back this week. Is there a motion we can entertain?
I'd like to report the bill with no action.
All right. All right. I think there's a substitute motion.
I'll offer a substitute motion to defer.
All right, and to which there is an objection. So we have a substitute motion to defer by Senator Luno, which there's an objection. So, Madam Secretary, if you could call the roll, please. Then a yes vote will be to defer, a no vote will be to not agree with the motion.
Senator Bishop?
Yes.
Yes. Senator Donahue?
No.
No. Senator Gaddy?
Yes.
Yes. Senator Luno?
Yes.
Senator Martini?
No.
No. Senator Melkovich?
Yes.
Yes. We have 4 yeas and 2 nays. So motion passes.
Thank you, Senator Hewitt. And I do intend to work with you on the bill we have on the floor that deals with this concept. I do think there's an opportunity there to try and get something done with this, and I hope we can work together and try and make that happen.
Thank you.
All right.